If you're going through a separation, whether you're married or unmarried, then it's really important to have a financial plan in place. And in order to do that, you really need to get advice at an early stage so that you know what your financial rights are. So if you are unmarried or not in a civil partnership, then your rights are going to be very limited to what you can show that you own during the relationship. So in that way, it's no different to living in a property with another co-owner, a friend, etc. If you are married or in a civil partnership, then the situation is completely different. As with a civil partnership, the court starting point is 50-50 and a fair division of all the assets that have been accumulated during the marriage and before the marriage. And that includes property, other assets like pensions, capital, savings, shares, everything like that. The only exception with regard to unmarried couples is that you can apply for financial orders in respect of children if you're unmarried, and the maintenance itself is dealt with through the Child Maintenance Service. The starting point for division of assets in a divorce is 50-50, and the court will look at all the assets that the couple have, and that includes assets which a person had before the marriage, that were accumulated during the marriage, and to some extent assets which may have accumulated the couple have separated. So it may be some time after the couple's separation, for example, that they come to divide their assets. And the court will look at the party's needs. They will look at whether a party needs to be compensated because they've given up a lucrative career to bring up children in the marriage, and then the sharing principle is the one that the court then applies across the board. So if we're looking at needs, someone who may have given up their career to look after the children, and the children may reside primarily with them because they were always the one who was the main carer, then their needs will be greater than someone who has a very good earning potential. And the court will want to make sure that the primary outcome is for the needs of the primary carer and the children to be satisfied. When we're looking at compensation, the court will see whether additional sums are required to compensate someone who has given up a high-flying career in order to stay at home and look after the children, and the other party's been able to go off and fly, really, with their career, and their earning potential is much higher. The stay-at-home parents' earning potential in the future is very much curtailed by the fact they would have had a massive gap in their career. And then finally, the court will look at the overall fairness of the division of the assets. So whilst everything is up for grabs, as it were, property, pension, savings, etc., the court will look at what may have derived from one party's family line, such as inheritances or anything such as a company that's come through one of the family members, and decide whether or not, in the interest of fairness, that those assets should be divided equally as well, or whether the needs of the parties are such that there can be unequal division of those assets.